As people are logging into the webinar, we'd like to wish a warm welcome, good morning or good afternoon to all the viewers joining us from across Canada today. We have an exciting presentation prepared for you and some great expert panelists who are going to speak on a few different topics. What I would like to do is introduce our expert panel, and then we'll ask Todd to perform the introduction. So Todd Louie is the first expert panelist I'd like to present. Todd is an expert in Canadian taxation. He's a partner at Quantum Business Law and a well-known educator, providing education to lawyers and accountants across Canada for many years on taxation. We have Michael Miller. He's again a partner at Quantum Business Law. He's been a litigator and a partner on Bay Street in Toronto for over 40 years and has a wealth of knowledge in litigation, civil litigation, and all types of corporate and commercial litigation, again, for many years. So we're happy to have Michael with us. Mahyar Makki, he's a partner also at Quantum Business Law. He's a tax lawyer with an emphasis on tax planning, tax litigation, and also class action litigation. We're very grateful to have Makki with us. And the last but not least is Jordan Louie. He's a partner at the Sheldon Group, which is a firm that specializes in scientific research and experimental development tax credits, preparing claims and defending them against the CRA. So we're happy to have Jordan with us. My name is Jeremy Louie, and I'm also a partner at Quantum. At this point, I'd like to call on Todd just to give us a brief introduction to the webinar, and then we'll jump into our session. Todd, please.
Yeah, good afternoon, everyone. Very nice to have everyone in attendance. When I was asked to give some kind of a preface to this material, one of the things that came to mind was the fact that I'm hearing and seeing many business owners out there having a false sense of security, sort of a feeling of invulnerability or immuneness, if that's a word, against lawsuits or claims. I would suggest that in the same way that you consider how to take precautions in order to protect your physical health, it might be prudent to consider your physical health in a similar way. Well, what do I mean by that? Well, the fact that you may say, well, I won't get sued. I haven't been sued. We have a tight ship here. We're fully insured and we have nothing to worry about. That's the message that I'm hearing. And I find that a little bit naive and in fact, bordering on what one might think of as Pollyanna. I would suggest that it would be more prudent to consider various different issues. So if you're looking to safeguard your physical health in the same way you do your physical health, well, clearly you're not going to ignore guidelines and recommendations from, say, healthcare professionals or fitness experts or nutritional experts on lifestyle and diet and, you know, the various issues like exercise and things like that that are pretty much established methods of ensuring that you have good physical health. Well, the same way, it comes with, first of all, not being naive. And I don't mean that in an unkind way. The word naive certainly does have a negative connotation, but I think part of the responsibility falls on you lawyers and accountants who are in attendance. It's not your role, in my view, at least, to tickle the ears of your clients or to give them information that they want to hear. I think it's best to give a wake-up call and say, where there's human beings in relationships with other human beings, well, there's always the potential for dispute, misunderstandings, certainly misinterpretations of the identical situation. And it's evidenced by two family members where you have two siblings, say, who are debating or arguing about something. Granted, they have a good relationship in general. They have the same different memories, but same experiences. Well, that's what happens in life. This is the wake-up call to say, well, wherever you have employees, you have business partners, you have suppliers, you have contractors, it's best to become aware of the fact that you might get sued. And I'm going to go out on a limb here and say, there's probably not much else you can do other than to be ethical, to treat people in a fair way, to position yourself in a fashion that you're treating people the way that you'd like to be treated yourself. But is that enough? Arguably, it's not enough. arguably there's more to it than that. Arguably, no matter what you do, if there's one place that's uncertain on planet Earth, it's the courtroom. So the fact is, we don't know what the courts will say. You might consider that all the things that could be done, you've done, and now you're going to say, well, I can't do anymore. Well, hold on a minute. There is planning that you can do to protect your assets. There is ways that you can mitigate risks. And there are things available to you that we're going to be introducing that every person who's concerned about their fiscal health needs to be considering doing. Now, we're going to go further than that as well. We're also going to be talking about the tax system in Canada a little bit more. And I guess that'll be no surprise that we're talking about tax again. Well, tax is far reaching. The tentacles of taxation reach into family law, state law, corporate law, practically every conceivable way. Our colleague, Chief Justice Bowman of the Tax Court of Canada said it best when he was asked, of all the areas of law, why have you gone into tax? Well, he said, I was interested in corporate law. I was interested in criminal law, but the one area of law that applies to every human being is tax. And although some people may look at tax as boring, well, we're here to give you a message that tax is an exciting subject, and it's a subject that can help you to preserve assets, commute them to the next generation, can help you to even receive benefits such as incentive legislation. So one of the issues with the Canadian tax system is it's founded upon certain realities. And one is the capability to utilize latitude in what you do. Well, what does that mean? That means that the backdrop of our system, our tax system in Canada, is predicated upon a very old case from England, which is the Duke of Westminster. And essentially what it means is all taxpayers have the right to order their affairs in a way that helps them to pay a lower rate of tax. Now, having said that, the counter side of that is we have to be concerned because we're in a minefield. We have general anti-avoidance rules that are intended to penalize or at least to prevent the abuse of a tax system. No, that's not what we're suggesting. We're suggesting that there's ways, and regrettably, these ways are generally unknown by most accountants and many lawyers, even, that give advice to clients, because the solutions to problems that are plaguing taxpayers remain elusive, and we're here to shed the light on some of these things to help you to achieve certain benefits that are otherwise unknown, out of reach, seem impractical. Well, there's too many misconceptions. And one other thing we're going to be communicating to you today is that CRA does not make the law. They interpret the law the way that you do and I do and everybody else does. And of course, we're going to be talking about a very exciting decision, a landmark case that's been heard by the Tax Court of Canada, where our own Mayor Makki, who's here with us today, was successful in an enormous victory that opens the door for countless taxpayers to be able to benefit from incentive legislation, whereas previously they've been excluded. We're very excited to be able to talk about these issues today, and we'd like to kick this off with whatever you want to do. Jeremy, why don't you take it from here?
Thank you very much, Todd, for your enthusiastic introduction. I'm displaying on the screen now what our agenda is for today's program. Everyone could take a quick look at it just so you know what to expect over this 1 hour presentation. With that, if everyone has had a chance to look at the agenda, we're going to move on to our next part, which is SR&ED Misconceptions and Strategies. So Jordan, please go ahead.
Yes, thank you, Jeremy, for that. And so, as Jeremy had already mentioned, I'm one of the partners with the Sheldon Group, and so we're a firm that operates really in all provinces here in Ontario. We file claims really for hundreds of companies each year, but we've also had involvement with SRED litigation, collaborating with quantum business law. And throughout our experiences, unfortunately, there's a number of misconceptions that became all too common within SRED, and some of them have really originated, unfortunately, with the CRA in that case. And so I really wanted to just go through a few of them. Jeremy, would you mind just displaying some of that information? Sure, perfect. All right. So the first one is that a product must be a new invention and not exist elsewhere. So this is a really common one we see. Oftentimes within SRED, I'd say really the vast majority of SRED claims are based around experimental development as opposed to scientific research and basic research. And in that case, it's normally incremental improvements that are being made to products, or small changes from a year-to-year basis. And the most important thing about SRED is that there's a technological advancement that's being achieved through that work. And so within SRED, as we'll explain a little bit later, that's referring to an advancement in the general understanding about technology, about the science behind their work. And so oftentimes that's done through incremental changes to products. Would you mind displaying the next one, Jeremy? Sure, perfect. All right. And so the next misconception is that you cannot benefit commercially from a SRED project. So this one's also very common. So as I mentioned, it's done under experimental development. It's not oftentimes done for the purposes of basic research. And I'd say really in the vast majority of cases, our clients are in fact benefiting from the projects. And like I said, the most important thing is that the work results in new technological information or technological advancement. Would you mind explaining? Perfect. All right. And so the third one is you cannot claim for a project where the product has been sold. And so this one, unfortunately, if you've been through an audit review, this one is commonly propagated by the CRA as well. And so the part of it that's true is that you're not able to claim for material expenditures when the product has been sold, but you are able to claim for the labor expenditures that was incurred in the process of experimentation for that project. Fourth one is, so the work must be completed by a dedicated research staff. And so this one is demonstrably not true within SRED as well as within litigation on SRED claims. Really from one of the landmark cases within SRED, which was Northwest Hydraulic Consultants, which Todd had mentioned briefly, which we'll be getting to further on. Basically, work must be completed by a competent professional in the field. They don't necessarily have to be a scientist. They don't have to be a formal engineer. They merely have to be a competent professional in order to be able to be claimed.
Jordan, I'd like to jump in just for a second on this point. As we're going to get into later when we talk about this landmark case that Mayor Makki had represented on, in his decision, Justice Hogan actually mentioned the fact that their client Airzone was a small company and that they do not have dedicated research staff, as most small companies do not. And it was his position in his decision that a company does not need to have a dedicated research staff in order to claim SRED. It can be the owner or the employees may have a large number of duties, and SR&ED may be part of their tasks and still be eligible for the program. I just wanted to mention that. Sorry for interrupting, Jordan.
No problem. No, that's much appreciated. And so the last one is if the project is a failure or remains uncompleted, it cannot be claimed. And so this is certainly false, as there's a very large number of claims, a very large number of projects that are continuously claimed on a yearly basis. Really, the most important thing is that there's still resultant knowledge that's gained each year. Incremental knowledge that's gained from one year to another. That's really what makes or breaks a SRED claim, essentially. I think there's one more actually, Jeremy, is there? And so this one is commonly told by the CRA as well. Oftentimes in a technical and scientific review, the reviewer will often ask, was this problem solved through the usage of known techniques? And so if so, oftentimes they'll say that they'll decide that it's ineligible for SRED. And so that's really been one of the reasons why many claims have ended up in litigation, in fact. But using known techniques does not solely render the claim ineligible. What's important is that there's an element of technological uncertainty within solving the challenge. So oftentimes, I'd say really the vast majority of experimentation throughout Canada, as well as the world, is conducted using previously established procedures and techniques and solutions, but there's oftentimes differences within the application or within the details that results in new specific knowledge being gained by our claimants. And so that, again, that's really one of the most important things when it comes to SRED. And so it doesn't disqualify work from being eligible.
Just to jump in, this is another topic that Justice Hogan talked about in his decision on Airzone. Specifically, the known techniques. The CRA took the position that because the client used known techniques to resolve their uncertainty, that it was ineligible. Well, in this case, the Justice Hogan said, no, that does not disqualify them from SRED, which is really interesting and we think a landmark case.
And so that really brings us now to what the definition of SRED is if you're interpreting case law. One of the cases that we'll go to further, but I'll say just sort of in a nutshell that SRED is the acquisition of knowledge that is not generally accessible to a competent professional in the field. And so SRED isn't only creating revolutionary technology that doesn't exist, but rather SRED is the work that results in knowledge that's not available within the field. That's really what SRED is. Important point to that as well is that this knowledge, it's not that it doesn't exist in other countries or in other places, but rather it's a question of whether or not it's generally available to the professional who's rendering the claim, whether or not he's able to find that information perhaps in a textbook or perhaps through sources over the internet, such as forums, or if he were to consult another engineer in the field, would they be able to give this information to them? That's really what the question is. And yeah, so if you want to go ahead to the next slide.
For sure. Just before we move on, I wanted to ask for Todd's viewpoint. We're calling this a case law definition of SRED. It's really more of an interpretation of case law. Todd, where does this interpretation come from and what's your view?
Well, I think before we deal with what the interpretation comes from, I think we have to deal with the fact that there are so many companies who are performing qualified activity that have entitlement that they're never receiving. And part of the reason is because of the fact that the definition of scientific research in Canada has been obscured. And I think that one of the problems that we have is that many companies that are performing it are being told, sometimes by their accountants or lawyers, and sometimes by CRA directly, that they're not eligible. Well, guess what? CRA is doing a good job of administering the program by and large, but often the wrong decision is made, and often CRA is applying a certain type of a criteria which is at odds with the case law. Part of the problem that we sometimes see is that CRA doesn't want to hear about the case law. They said, I don't want to hear about the case law. We're not here to talk about that. We're here to talk about your claim. Well, that's not how it works. The fact is that in common law countries such as Canada, the law is established through incremental changes, kind of like in SRED, but through the courts and what the courts decide. So I think that it's incumbent upon the minister to look at these cases from time to time. And I believe that that can be a losing argument. So I think that one of the problems we have is that it's necessary at times to go a step further, to go to court in order to have this established. But as far as this definition, well, I think of Chief Justice Bowman's decision of Northwest Hydraulics that Jordan was mentioning a minute ago. And he basically made the following comment. I'm going to paraphrase it because my memory is good, but it's not very long. And what I recall him saying was that systematic investigation is defined in a certain way and advancements are defined in a certain way, but routine engineering is defined as techniques, procedures, and data that are not generally accessible to a competent professional in his field. Well, that's very important because if you take that definition and you turn it upside down and reverse it back, it means that if you are if you're simply doing the same thing that you already know, and you're following a certain protocol, it doesn't mean that you're not performing SRED, because SR&ED comes from data. Chief Justice Bowman said what is not eligible. In other words, routine engineering is techniques, procedures, and data that are accessible to a competent professional. Well, what that means is if the data that's known, the information that's known on the public domain is insufficient to resolve your specific problem, then you may have SR&ED. As a matter of fact, I'd argue that you do. If you would consider, when it was discovered that the universe is expanding, there was a telescope that was used in order to observe the solar system. Just because Aristotle used a telescope, does that mean that it's not scientific research? If he discovered something profound, well, guess what? Chief Justice Bowman also said that you only require an infinitesimal amount of knowledge gained. And for those of you who are mathematicians in the audience, you know what that means. As I recall, it means a number that's more than 0, but less than 1. In other words, a very tiny amount. You don't need to discover that the universe is expanding. You don't need to develop a cure for cancer. You need to discover knowledge. You need to acquire knowledge that's not generally accessible. And you do so through experimentation, research, and analysis. So there's so many companies, I'm sure, who are listening today who have a production line. And guess what? They made a little tweak here and there. They ended up improving. They've learned something. So those of you who are in attendance that either are lawyers or accountants or business owners, if you're learning something about your technology, please look at this as an opportunity to perhaps come to the table and take what's yours. It's there for that purpose. The legislature in Canada intended for the interpretation to be broad and liberal and to be generous. And that's what drives the economy in Canada. And in the wisdom of the legislature, they seem fit to open the door to taxpayers who are deserving.
That's a good point, Todd. Just going back regarding Northwest Hydraulic Consultants, just some background on this case. As Todd had mentioned, it was very much a landmark case within SRED, and it's been cited really in nearly every case in the tax court of Canada that's been held that's been regarding SRED. This decision has been cited that the Honorable Chief Justice Bowman had made. And so, as some background, Northwest Hydraulic Consultants, they made new designs for dam and dike systems that would be implemented across North America. And what the CRA's argument was to deny the claim. It was based on their technology being used, being quite well known as like dams and dike systems have been implemented as far back as ancient Egypt. And so they argued that really that since it's such an old industry, essentially, all the information was already gained, and there couldn't have been any technological advancements that Northwest Hydraulics could have gained through their work. And the way that former Chief Justice, the way that the Donald Bowman had viewed it, was that there were incremental advancements that were made in terms of what modifications we made to these dam systems, even though they may have been minor. What new information did they gain regarding turbidity, regarding the turbine design, regarding what grates were used within the system to be able to prevent debris from affecting the operations of these dam systems? And that's what they demonstrated. They demonstrated that they didn't make a groundbreaking discovery within the hydraulic knowledge, but it was incremental knowledge that was gained. It was infinitesimal knowledge that was gained about the industry, about the science behind their work. And that's exactly why the former Chief Justice, he made the decision that he did, and that the work was eligible for SRED, was a technological advancement.
Thank you so much, Jordan. And we're almost out of time for this part, but I wanted to touch briefly on the idea that we will be getting more into later on a broad and liberal interpretation of the law, as Justice Bowman, both Justice Bowman and Justice Hogan in their decision stated that SRED should be applied in a broad and liberal fashion. Can correct me, Todd, if I get the words wrong. But Jordan, according to this slide, how should a taxpayer be interpreting the rules for SR&ED and deciding what projects and activities they should claim?
Well, I mean, within SRED, if a technological advancement truly is about gaining new knowledge that's not generally available, really that's something that should be claimed every single time it happens. Every single time a taxpayer is gaining new knowledge, even if it is incremental, even if it is something very tiny, it should be a part of that SRED plan. That's for sure. That's what claimants have a right in law to do. And there's really no set limit as to the number of projects they're claiming for or the duration of them.
Thank you so much, Jordan. Todd, do you have any more, did you have anything else to add before we move on from the topic of SRED and we start to talk about Airzone?
Well, sometimes we can't see the forest for the trees. I recall being invited to a fireside chat by Greater Toronto Accounting Group. I forget what the name of the group was, but anyway, myself and Chief Justice Bowman, as he was then called, had a conversation about how we determine eligibility. And one of the things that sticks out of my mind is Chief Justice Bowman said, "I'm only glad that Sir Isaac Newton didn't apply for scientific research," which I think suggests that there was a target that had evaded most people claiming for scientific research. And of course, concepts such as, learning things by chance and not, performing a systematic investigation. All of those things are true. But please, it's important to understand that when we consider whether SR&ED has been achieved, it's better to, at least in my view, to try to put it in real clear and tangible terms. And the best definition that I've heard for scientific research, tax credits, is it means the acquisition of knowledge that is not generally accessible to a competent professional in his field. And the reason I'm suggesting that's a good definition is because the term data refers to knowledge. And we have reinforced case law now to stand behind the fact that these kinds of improvements and even another term that we're going to hear today, and Mayor, you can refresh our memory on what that term was, that Justice Hogan had mentioned. Is it optimization?
Yes, optimization.
Amazing. The term optimization should be one that all taxpayers in Canada should be looking to determine whether or not they have achieved that. I think we'll save that for the next session.
Yeah, that's right. Good information, Todd. And so just one last point when it comes to really what the scope of SRED, like oftentimes in SRED, companies are only looking at some of the larger projects that they believe embody the 3 eligibility criteria. But since you are able to claim for really even incremental and infinitesimal advances in knowledge, those small occurrences, even if they took a very short period of time, it should be a part of each claimant's claims. And I mean, what you need to look at is ways to be able to combine such occurrences. And so we look for common denominators, common technological uncertainties that a company is encountering across a year, and then you're able to combine those projects together into one singular SRED project, and that really expands the value of SRED claims substantially, much more than the claim. These small occurrences, when you combine them, they can be far larger than even the biggest typical SRED projects.
Thank you very much, Jordan and Todd. At this point, we'd like to move on and call on Mayor Makki. He was the counsel for the appellant in the Airzone case. And Mayor, can you start by giving us a little bit of background about the case before we jump into why this is a landmark case and why this is so important for taxpayers to know about? Can you start with some background?
Sure. Thank you, Jeremy. Thank you, everyone. This case was a highly technical case. There were 6 projects involved in the case, spanning over 2 taxation years. And mainly our client was hired by, a lot of times, by World Health Organization, the United Nations. They do significant work. And we're proud to represent clients like this. And they're leaders in the world, a lot of times, in cutting edge technology. A lot of it was based on different types of chemistry, atmospheric chemistry, and how, although they've been a leader in optimizing certain chemicals and measuring reduced sulfur compounds. As the sulfur compounds, for instance, would leave the source, it'd be harder to measure. So yes, they've spent the past 30 years measuring these compounds, but as the compounds leave the source, they have to come up with new methods to measure the new reduced sulfur compounds, and that was the basis for a lot of their projects.
Thank you, Mayor. Earlier in this presentation, we talked about a few things. Todd just brought up the word optimization. What did optimization have to do with this case? And afterwards, what did Justice Hogan have to say about optimization in the context of SR&ED?
Right. So what a lot of times happens, and what we see in the SRR scientific review report, is that the SRED claims are disallowed when the reviewer feels that the work being claimed was optimization. This case stands for activities associated with optimizing products or processes are no longer ineligible, which is a big deal. Now, optimization is seen as qualifying for SRED. So we're happy about that. And it expands the definition of SRED to include optimization.
Yeah, I think some of us may argue that optimization should have always been part of the definition of SRED, based on the legislation itself and even on Justice Bowman's Northwest Hydraulics decision. Todd, do you have any comments about that?
I think so. Before I do that, though, I would be remiss in not congratulating Mayor Makki on this incredible victory, right? And my comment to Mayor was, on the day that he won the case, was that every tax lawyer in Canada will know his name, right? I believe that's probably true, right? Well, not that they didn't already, but if they didn't, now they do for sure, right? So
thanks, Todd.
They may not know how to spell it, though.
Yeah, right. So the fact is that the entire argument needed to be refined, and of course, there's been a lot of cases that have been heard, and some of them haven't turned out the way that they may have turned out. And I believe that it's very important to recognize the legitimacy of claims that involve optimization. I've noticed a couple of questions coming in. Well, about one, if engineers are tweaking something and fixing it, well, is that scientific research, and does it qualify for tax credits? Well, I think that it's very important, just as a starting point, to say that if you're improving upon a product, a device, or a process, that's in the Income Tax Act. A systematic investigation ought to be included in that, of course. In other words, it's not something that you're throwing darts blindfolded. It's something that you're doing experimental development, as according to the Act. That means you're developing something experimentally, whether it be a product, a device, or a procedure. Well, it can certainly be eligible, providing that you have improved upon the actual product, device, or procedure in a fashion that caused you to resolve something that was unknown, more specifically what's called a technological uncertainty. And to the extent that this was done through this type of campaign or systematic investigation, where you analyze a problem. If you think of a high school science project where you formulate a hypothesis and then you seek to confirm or modify that, depending on the result of your experiment, that would in many ways denote what we think of as a systematic investigation. But the Income Tax Act provides that where there is knowledge gained, and that's echoed in the best case law. And our dear friend, Chief Justice Bowman, has really defined this well. And I see the last several decades as being one of those situations where being involved with scientific research, popular views and opinions, also in some cases, unfavorable treatment for qualified work not being recognized. So Justice Hogan, in his wisdom, was able to see that an improvement or an optimization of an existing product can be eligible. And in this case, several projects were found to involve that. And of course, you see CRA saying, well, it's only an optimization. Well, so what? It's not about the product, it's about the knowledge. And optimization means you've discovered something, even if it's small, that has made it better. So I think that this decision just, is a very welcome decision and a new opportunity for taxpayers across Canada who are optimizing procedures and products alike. And that includes software, anything else, manufacturing. You got to ask yourself that question. Have you optimized your products? And if you did so, did it involve knowledge gain? And if so, it's time maybe to reconsider whether or not you should be applying. And if you lost the claim already, don't forget, it's not CRA's decision as to whether you're eligible or not, it's tax courts. And our firm, having this case led by Mayor Makki, has opened the eyes of many of us and helped us to better understand how small incremental improvements in practical terms can represent eligible work that should be claimed.
Thank you, Todd and Mahyar. One thing that I found, just to wrap this up, one thing that I found interesting was in his report, the reviewer had actually mentioned that the client did optimize, that the claimant did optimize, and that's one of the reasons why he denied the claim. And it's very refreshing to see this type of decision that we did from Justice Hogan. Another thing that jumped out to me when reading this decision was the fact that Justice Hogan talked about the fact that the reviewer denied the claim because they used known tools and they used known techniques in resolving their problem, and as one of the bases for denying the claim. Can we have some comments on that issue? Why is this significant that Justice Hogan says that that using known tools and techniques are not a basis for denying a claim?
You want me to jump in quickly? So I think a lot of times we have around over 20 matters in front of the tax court of Canada. 70–80% of them are SRED claims. And what we see a lot of times is a lot of these are highly technical cases, and not everyone, for instance, if we're talking about atmospheric chemistry at the highest levels in not only Canada, but in international organizations such as the United Nations, World Bank, World Health Organization, it's the highest level of cutting technology. You don't have such qualified people grappling with it. So what happens is a lot of times the CRA gets stuck on the tools, right? What happened in our case was they said, you know what, you're using routine techniques, but it was a mistake because they were really stuck, and Justice Hogan hammered this point home, was they were really stuck on the instruments used. This case wasn't about the instruments used. This case was about creating new methods using existing instruments. And we considered that it was using existing instruments, but so what? As Todd always mentions, you could discover cancer using microscope, right? Microscope is routine. It's routine to use a microscope. Same as this case. They used a lot of known instruments. We did not hide that because we didn't think that's where the SRED was. The SRED was new methods. And I think a lot of times, unfortunately, what happens, the CRA gets stuck with the instrumentality that's used.
I just add to that to say that oftentimes the way that some people have been trained at CRA, and most of them do a very good job, but we've seen a certain approach that says, what did you do? Just tell me what you did. And they control a meeting. And if you describe only what you did, you're leaving out the advancement, because what you did is not the advancement, it's the road to the destination. And it clearly trivializes eligible work when you simply describe a sequence of tasks. I would fathom a guess that, as Mayor mentioned, a cure for cancer might be developed by someone someday, and hopefully it will be. But I would suggest that if you were to quiz or interrogate or cross-examine or otherwise dig into what that person did. He would probably say things that seemed very perfunctory, very basic. It happens up here. This is where we learn through observation. You put me beside that scientist, well, I'm looking at something and I don't really know what I'm looking at. And I'm not going to see the same thing he does. It's what the performer sees. It's what the performer extracts that makes an advancement, not what he did. And it's frustrating to see that the persistence that some of the people at CRA have had, and if you're listening today, I implore you to consider the fact that it's all about the advancement in knowledge, and the actual method of getting there is only a roadway that should not be a pivotal point when you consider whether the work is eligible for scientific research.
Thank you very much, Todd. Before we move on, did we have any closing comments about this case, or should we move on?
I just wanted to add one more thing. I think we have to look at the intent of legislature, and that's what Justice Hogan touched on in paragraph 51 too. He stated that I am of the opinion that the Y factor cannot be so strictly applied that only large corporations that employ dedicated research staff can qualify for SRED. Moving the goalpost so far afield, in my opinion, would be contrary to the intentions of Parliament, which was stated in Northwest Hydraulics. Tax incentives given for doing SRED are intended to encourage scientific research. As such, legislation dealing with such incentives must be given such fair, large, and liberal construction and interpretation. And I think that's what he touched on in this case too. This incentive program was meant to be given liberal interpretation, and sometimes that's where the sticking point is. We think it should be more liberally construed, and others may think it should be stricter.
Thank you, Mayor. I'll just say once more that we're very proud of the job that you did, Mayor Makki. You did a great job on this case, and the whole team at Quantum is very proud to have played the part that we did in this case. Now we'd like to change gears a little bit. And talk about the next topic on our program, which is post-COVID litigation. Now, the world has been turned upside down for a little over 2 years now. There's been lockdowns put in place. There's been businesses that have gone under. There's been contracts that have gone unfulfilled. So many things have happened. And I'd like to turn it over to Michael Miller to give us some more color on this topic. Please, Michael.
Thanks, Jeremy. So in 2018, Ontario passed Bill 218. It was June of 2020. I think I said the wrong. It's Bill 218, and it was passed in 2020. And that bill protects corporations and individuals from lawsuits being claimed against them because of something related to COVID. And so the government has prohibited lawsuits against corporations and individuals. This is a big step and affects many people. They called this a supporting Ontario recovery. And I guess the question that I have is preventing someone to do a valid lawsuit supporting recovery or just helping corporations. But nonetheless, if the corporation or individuals acted in good faith, and did a good faith effort to act in accordance with the current public health guidance, then they're relatively safe from lawsuits. However, it does not cover gross negligence. So if you've done nothing and haven't properly protected yourself and protected your assets and done what was required by the governmental regulations, both provincial and federal, then if you are found to be gross negligent, that lawsuit can survive. So it means you have to first prove to the court there was gross negligence. We know about all the supply problems that everyone's having in every industry. Anyone needs a new bed, you're waiting 4 to 6 months, let alone new refrigerators, all of these things. And they're going to be around for a while. In fact, it could also get worse. And then there are many lawsuits going on in that avenue because that space has provided that if you make a product, it's made up of a whole bunch of other products. And if you can't get one of those other products, your whole product fails. And so who's responsible for that? The supplier, the manufacturer, the person ultimately bringing it to market? It's a question that the courts will decide, but it's been very difficult. The courts are fully booked, backlogged, something that would have taken a month to 2 months to get before a court on a motion, for example, takes now about 18 months. And all that costs the clients more money, more time, more effort. And there's been many long delays. I want to talk, if I can, Jeremy, about a recent case in Ottawa that has struck me because it's striking, I guess. So this is a claim that was brought saying that the defendants, and I'll tell you who the defendants were in a moment, were allowed the bringing in of COVID restrictions. So the defendants made it possible for there to be COVID mandates and make it into law and due process. And they're saying, this case is saying the mind, the body, and the health of the Canadian public is at risk. Mind, body, and health is sort of an interesting way to figure out what the case is. And is any of that actionable? We'll find out soon enough. But the problem is that it appears to be frivolous and vexatious, this case. And the lawyer representing these parties, the plaintiffs, have said, well, of course, the government's going to say it's frivolous and vexatious. That's not a throwaway. If it is frivolous and vexatious, then why wouldn't the government say that? But that doesn't matter to these people. They're proceeding as far as they can go before a court stops them. Now, I'm going to just tell you who the defendants are, and then the viewing group can decide in their minds whether it's frivolous and vexatious. They sued the regulator. They sued Bill and Melinda Gates Foundation. That's pretty interesting. They've sued the World Health Organization, which I think will be a difficult case. But what makes it most frivolous and vexatious to me is they've also sued the Pope. And in all of my years of practice, and there's been a fair amount of them, I've never seen the Pope sued for this type of thing, but Ottawa law firm is doing that. I guess the point to take from that is that everyone's vulnerable. Everyone's vulnerable in one sense or another. Anyone can sue anyone. Doesn't mean they're going to win, but in the meantime, you have a huge cost in defending yourself and in trying to get the action struck, and time and effort, and that cost is very expensive. And it's a cost that you haven't planned on. And how have you protected your assets when that's happening for something that you never thought would ever happen? I don't think the Pope himself knows about this lawsuit, but still it will have to be dealt with in some way. And it's just an example how lawsuits can come from left field and have you properly protected your assets. I want to just give you a few examples of who are the people who are being sued now. And I think the number one and probably the most real one is the long-term care operators and owners. They've been hit by many lawsuits, and these lawsuits are claiming negligence and gross negligence. It's because of insufficient protective equipment, and the slow reaction of these long-term care homes to COVID, staffing shortages, inadequate safety protocols. So there were many deaths and many illnesses. People have been lost their lives as a result of this. And so the long-term care operators are being sued, and these are still in the courts, and we'll see how it comes out. But they're very much at risk. Ontario, I know, and other provinces as well, has stepped up to clean up these operations, but still it's a big problem. The next one is breach of contract, and anyone who is flying or attempting to fly or taking trains during COVID, and those, because of government regulations, those trips have been canceled, and so you can't fly. You want your money back. It's taken a long time for Air Canada and WestJet and other airlines to say, okay, here's your money. A lot of them were saying we'll give you a coupon for future travel. Some were saying, well, we'll give you some money back. But because of the government and other groups that were speaking up for all the people in this situation, they now are giving the full money back, which is something that should not have been a question. But that breach of contract comes up in that sort of situation, and the breach of contract once again comes up where the manufacturer says to a supplier, I've got a contract for you to deliver all this stuff to me, and you haven't done it. So have they breached the contract, or has the world events made it impossible for them to fulfill it? Another one is that insurance companies have been denying business interruption insurance claims. There are many of these where the business just could not continue on. And what the bottom line is, the insurance companies, not surprisingly, are fighting these cases. They have not been preferred to settle. They're fighting, and they say it doesn't qualify. COVID government ordered closures does not qualify as business interruption. They say business interruption is for physical damage to the business, and COVID does not cause physical damage to the business. So these cases are being soon to be decisions coming out as to how that's to be determined. It has wide-ranging effects. There are not many actions against the government itself, surprisingly. The most notable one is prisoners who have joined together, I'm sure through action groups, suing the government for unsanitary living conditions and overcrowding. They say that's heightened the risk of COVID-19. I'm sure they have an argument. What's happened now is that litigation periods, which were 2 years, have now been extended. They've been extended because for some period of time, the courts have been closed. For other periods of time, the courts are bogged down. Other periods of time, people have not had access to their lawyers, and time has gone by before they could reach them, or before they could decide whether they have a case or not of any validity. So the courts have said, we're going to hear why you haven't done your claim within 2 years, but give a wide berth to those who have a good reason why they haven't. And that still exists now. And then I want to just talk briefly about employment contracts that our employers and lawyers and accountants are dealing with. You just can't give someone the same notice period as you have up until now, or as the law provides. Because of code, you need a reasonable notice. And the reasonable notice basically is interpreted as a longer notice period to give the employee when you are going to cancel their employment. And that's because one of the indices of what an employee deserves when he's being terminated or she's being terminated is that are there plenty of jobs in the workplace that person could go to? Because of COVID, there are not plenty of jobs around in any particular workspace. And so they're making, helping the public in general by doing that. And that's become important. How long it's being extended is open. It also depends on each case. There are just causes of termination, however, if an employee just violates COVID-19 safety policies. So if the policy is that everyone must mask up and stay separate from each other, if an employee just disregards that, that is cause for just termination. They're also deemed to be COVID-19 related layoffs seem to be interpreted by the courts as constructive dismissal. So if it is constructive dismissal, then the pay in lieu of notice or the notice periods must have reasonable notice, as I mentioned. An organization-wide changing to compensation due to COVID-19 also amounts to constructive dismissal. I just have two more quick things I want to add. One is SRED. We all know in the news this week that the government's looking at $81 million they paid out to SRED applicants, which they believe may or may not have been appropriate. They're now looking into it. They've sent out letters to these people, and they will be processing it. One of the main things that happens in the world that we live in now is the governments are spending a lot of money. They're now looking to get it back. And people who have received SRED, who have deceived the government, who have committed fraud, whether they're aware of it or not, are going to be told they must pay it back. That will be interesting to see if the people who got served cannot pay it back, what's going to happen. And lastly, for those who do have employment contracts, I suggest you clearly look at it again and review with your legal advisors to see if there's a force majeure clause in it. If there isn't, you may be stuck with all sorts of responsibilities to your employees. If there is a force majeure clause, COVID would fit into it, and you may get away with being able to take the action you want. So review your employment contracts.
Thank you so much, Michael. You have a great wealth of knowledge. If anyone is needing or interested in discussing litigation or has questions, please reach out to us and we'd be happy to talk to you. The next and last topic for our presentation today is the wage subsidy, the Canadian Emergency Wage Subsidy. That's one case where the CRA and the government are under increased pressure to audit companies who've been receiving this wage subsidy. They've been paying out millions and millions of dollars. I'd like to call on Mayor Makki just to talk a little bit about that and some of the things that the government is looking at right now. Mayor, please.
Thank you, Jeremy. So there's a lot to say about wage subsidy, but I'll just give you sort of an anecdote. We've been helping clients, several clients with their wage subsidy issues with they've been audited. And we were successful recently in saving a client over $400,000. How we did that was when you're calculating the drops, like you have to show a 15% drop, then different places and time, there's different percentages. But Section 125.74E allows for an election to either for qualifying revenue based on either the cash method, which means money or revenue is recognized when the money is received, or the accrual method, revenue recognized at the time of sale, even if money hasn't been received yet. By choosing one of the methods, a taxpayer may defer or bring the forward revenue, which may affect their eligibility for wage subsidy by meeting the drop percentage, whatever that in that time it is. So what we did was through the audit phase, we sat with the client and we looked through all their revenues and everything, and we kind of ran a system. What we use the cash method or the accrual method, and saw which one would be would help them qualify best, and we were successful in that audit. So we, whether it's that or other methods, we're moving forward with clients, and we've been quite successful with this wage subsidy.
If I could just interject, I think that there are no shortage of ways that all of us can be vulnerable. Michael has given you examples. Rather than 15 minutes worth, he could have given you 15 hours worth. So I would again stress the importance of asset protection. And no matter how or why you may feel as though your assets are out of reach, they're not. So how do you essentially arrange your affairs to reduce and even eliminate liability? For those of you who own businesses or are lawyers or accountants of those who do, I would encourage you to consider the concept of an estate freeze for various reasons. An estate freeze is one of the tools in our tax planning toolbox that are often misunderstood and overlooked, almost like SR&ED. In reality, there are no ways to provide true protection if, as a business owner, you hold the shares of your companies directly. Well, you say, oh, no, I have a holding company, and it holds the shares of an operating company. Not good enough, because you still own the shares of the holding company. Someone sues you personally because you hit a guy at a crosswalk that can't walk the rest of his life, and he happens to be a billionaire, and your liability insurance is only $5 million, and he sues you for $30 million. Well, you could consider the assets that you have, including the shares of your company, to possibly be in jeopardy. There's many, many other ways that you can be sued, and various different kinds of disagreements can arise. Laws that provide for the efficacy of trusts are often not understood sufficiently by advisors and business owners alike. It's often the case that it's necessary to set up a trust in order to facilitate the future growth of your company and to commute the value essentially intergenerationally. And by doing that, you can achieve a result that can safeguard assets, because the law of trusts is such that the only individuals who are capable of benefiting are the beneficiaries, who is your family members. So if there's a claim against you personally or against one of your companies, you're achieving a certain amount of protection. I'll also mention that on the tax side, Mayor is talking about wage subsidy and CRA now coming back, and there's hundreds of audits going on for people who claimed wage subsidy. CPP EI insurability is another one, which is often a problem for companies that have contractors instead of employees, where CRA comes in and says, well, these are de facto employees, right? So you've got to be very, very careful, because a negative assessment against your operating company can have the effect where CRA applies section 160. That's section 160. We've seen that happen to individuals. We've seen it happen to holding companies, where even if you're considering you have a limited liability company and the assets are safe, again, you've got to think again. You've got to look at that and say, well, in reality, you still have a certain vulnerability to a negative assessment by the CRA that can have the effect of CRA reaching up into that holding company. And then, of course, we see situations where business owners have been told, oh, you're too young for an estate freeze. Company isn't big enough. Well, when our firm assists enterprising companies from day one, we affect the equivalent of an estate freeze if the company is likely to grow. And I don't care whether the person's 60 years old or 20 years old. If the company is likely to grow in value, then it makes sense for a number of reasons to do planning. And because this is a misunderstood area, many people don't realize that you can reduce taxes through capital gains exemptions at time of death, or when you sell a company, and multiply that by having a family trust and beneficiaries of a trust to include family members. Also, many people don't realize there's certain tax benefits that can be achieved. And I'm not suggesting that we would for a minute consider tax planning that's aggressive. Quite the contrary. Oftentimes we would consider going outside of Canada to other jurisdictions in order to achieve asset protection. Canada has legislation which is antiquated, and legislation which works in favor of creditors and does not work in favor of everyone else. There are many reasons why trusts in jurisdictions outside of Canada, such as Barbados, St. Lucia, New Zealand, are all places to consider trusts, not for aggressive tax planning, but to achieve asset protection that is not in Canada. There are even US jurisdictions that have asset protection: Nevada, Alaska, Nebraska, to name a few. What we're not advocating is aggressive planning, situations where individuals are transporting companies to what's called continuances outside of Canada, to places such as British Virgin Islands, as well as Delaware. What we're suggesting is that there's asset protection jurisdictions that can be used to hold not your cash, not your stocks, not your assets, but only shares of company that holds those things, in a way that can achieve your long-term goals of recognizing family members as shareholders of companies, and as a natural consequence can result in significant tax reductions on capital gains. Rather than being taxed at 25%, it can be reduced to only 13.25%. And tax on passive income can be reduced from 50% down to 26.5%, but only as a natural consequence where there's a bona fide purpose involved, such as trying to protect assets. Failure to plan is the most expensive thing. If you have insurance, then you obviously believe in protecting against unforeseen occurrences that can work against you. Well, I can assure you that if you have a successful company, the kind of planning that I'm describing makes all the sense in the world, is much less than you're paying for your insurance, and gives you real insurance insofar as you can't buy protection to guard against some of these issues. So this is something that is not out of reach for a company because they haven't achieved a certain sales volume or a certain value, or a shareholder has received a certain age. Oftentimes when accountants and lawyers are uncomfortable about a subject because they don't necessarily understand nuances involving things like reasons, how to do an estate freeze, when to do it, the easy answer to say is you're too young, not the right thing for you. And that's it. Well, we're suggesting that you accountants and lawyers take the time to dig a little deeper into these nuances and make yourself available to point out some of the benefits that most often gets lost in the wash.
Thank you so much, Todd, and to all of our expert panel, thank you. If anyone in the audience has any questions about what they heard today, please feel free to reach out to us. If it's within our wheelhouse, we'd love to talk to you. Todd, all that stuff is so interesting and applicable. It sounds like there's a few topics there that would be great topics for future presentations, actually. But now we'd like to open the floor. If anyone has any questions, feel free to put them in the chat or in the questions and answer section. That concludes today's presentation. So thank you to all of our viewers for tuning in today. We host regular webinars on topics such as tax, SRED, litigation. So stay tuned for the next webinar. If you have any questions, feel free to ask them now. And thank you again for attending. Looks like we don't have any questions. So on that note, stay tuned for our next presentation, and thank you again. Take care, everyone.
Bye.